Hey everybody, Nick Espinosa, your chief security fanatic here, and today we have to talk about social media, all social media here in the United States, because they just had their legal foundation destroyed. I am not making this up. This is actually super important, and thank you very much, Texas and the Fifth Circuit Court of Appeals here in the United States, for putting us in this, for lack of a better term, predicament. Now, here's what's going on, and this is coming from Protocol. A surprise ruling yesterday by a panel of 3 federal appeals court judges allows Texas's new social media law to go into effect, and this has led to, as Protocol puts it, panicked befuddlement among technology experts wondering how these platforms could possibly comply even if they wanted to, and what options these platforms like Facebook have for challenging this ruling. Now, the judges ruled 2-1 that the law should be effective while they hear an appeal by 2 big tech trade groups of a district court injunction that basically had put all this thing on hold. The judges did not immediately publish their reasoning, but the move will now force social media companies like Facebook or Twitter to face a legal environment that could do things like threaten core content bans, could threaten moderation practices, as well as ranking algorithms. And obviously, they've been doing these things for almost a quarter of a century at this point, since way before the dominance of Facebook. And here's what's going on. This is essentially HB 20, or House Bill 20, is now in effect. And by virtue of that, Texas users can sue platforms like Facebook and Twitter if they believe they have been quote unquote censored for their viewpoints. Now, that obviously is a very vague premise, censoring you for your viewpoint. This was essentially a politically motivated situation designed by conservatives in Texas who claim that big tech, the Facebooks of the world, have been unfairly silencing them and basically downranking their content. Studies of, interestingly enough, independent studies of Facebook have shown the exact opposite, that they get a lot more play, but here we are. Now, until this week, industry observers expected that the court was going to uphold the block on this law. In addition to the lower court's injunction, a different federal court also paused a similar federal law, finding that it violated the First Amendment in seeking to punish private companies for their views and their treatment of content. Again, this is a private company. They can do what they want. You don't have to use Facebook if you think they're censoring them. Leave. And a lot of people have. I'm not a fan of Facebook. There you go. Now, those decisions also echoed essentially all the precedent that the Supreme Court has put out already on this case. Obviously, we now have a different court makeup, so we're going to see what happens. And so, according to Protocol, and I will quote them directly, but instead, the Fifth Circuit judges appeared to struggle with basic tech concepts during a Monday hearing, including whether Twitter counts as a website, before issuing Wednesday's startling decision. Now, obviously, this is a problem that we have. It was the same when Mark Zuckerberg went in front of Congress and essentially, I think it was a senator or a congressman that said, well, how does Facebook make money? And it's like, really? You're going to spend your 5 minutes that you have with Mark Zuckerberg on his egregious data violations, and you're going to ask him how he makes money? I mean, this is the problem that we have. I tweeted out then that, if basically all the senators and the members of Congress had let their grandkids question Mark Zuckerberg, he would have been screwed. As soon as that question hit, Mark Zuckerberg's stock went up something like $3-4 billion. This is a problem we have, especially with the older generations. And it's no offense to the older generations, but if you don't understand the platform, how can you possibly rule and adjudicate against that? This is a huge problem. Now, Matt Schurers, who is the president of the Computer and Communications Industry Association, one of those big lobbying platforms, basically these are one of the 2 groups that are challenging these kinds of laws, said in a statement that, quote, no option is off the table as far as challenging this ruling and the statutes therein. Now, a lawyer for NetChoice, which is the other plaintiff, said that they would absolutely be appealing this. Now, one option for these groups is to seek what is known as an en banc appeal. That's basically a rehearing by a larger panel of judges on the same court. The Fifth Circuit Court, if you didn't know, is considered the most conservative circuit court in the United States. So we'll see where that goes. But instead of going in front of 3, they would go basically in front of the entire court to get a greater ruling. But the decision on yesterday, may actually signal that an even larger group would come to a similar conclusion, and that's according to David Green. Basically, he's the Civil Liberties Director at the Electronic Frontier Foundation. Big fan of those guys. Now, the EFF supports basically these platform suits in this brief. The law is constitutional, according to the EFF and Mr. Green. Quote, "My hope is at some point a court will agree that and strike the law down, but I think that's only going to happen at the Supreme Court level." Now, there are two ways that these companies could end up in front of the Supreme Court. They could skip the en banc hearing and start by appealing to the Supreme Court directly, or they could try to bring the case there after another loss in appeals court. It seems to me that the safer option would be to go through the en banc hearing, but there you go. And I say but, the majority of those 9 justices may not see a reason to jump in at this stage and instead could hold for a time when the companies are actually facing lawsuits permitted by this Texas statute. Meaning, as soon as this goes into law, you're going to get that one person in Texas that says, "I am suing Facebook," and it's game on. So we're going to see what happens here. But this is obviously a huge thing. And as we are looking at the makeup of the Supreme Court, and obviously everybody's focused on Roe v. Wade, this could be in right behind it. Basically, Facebook gives you the ability to say almost anything that you want to say, but they've had crackdowns on things like misinformation and disinformation campaigns, or things that they consider offensive. And quite frankly, that's their right. They are not a Title II. They do not act as a public utility. They have every right to censor it in the same way that I, as a business owner, have every right to work or not work with individuals or corporations that I choose. Nobody can force me to do that. So I think this is going to be a very interesting thing. I actually disagree with this ruling. I think that Facebook, Twitter, and any platform out there, quite frankly, I don't care what you are on the political spectrum, has the right to basically administer this as they see fit. Consequences be damned. The consequences should be people leave. And when there was a huge push for people to leave and move to Parler and some other basically social media platforms, especially those on the right that said, well, I'm being censored and I can go to Parler and not be censored, understand that Parler's CEO wanted to also enact content moderation policies, and the board kicked them out, and the board is now enabling content moderation policies because you can't really have a platform without some kind of content moderation. Now, in terms of downranking and other things, that's obviously a case-by-case basis, but if you are demonstrably putting out misinformation or disinformation, meaning you're intentionally putting out misinformation, not realizing or actually knowing it's misinformation, then downranking makes a whole lot of sense, because we have a huge problem with that right now. And it's not that anybody can't see it. They're not banning you. I can go and read whatever you're putting there. They're just not wanting that to spread to a greater audience. And that's the problem that we have. We're oftentimes playing out of 2 different sets of playbooks, when in reality, there's usually only one truth that can be subjectively twisted one way or the other. So we're going to see what happens here. I think this ruling in the long run will probably get struck down, but with the makeup of the court, the new basically 6-3 conservative Supreme Court, this may actually stand, in which case Facebook, Twitter, etc. have been forever changed, meaning we can sue them and we can possibly sue them into oblivion. Now, this is above and beyond the standard lawsuits that we see coming out of Europe against Facebook and Google and all of that for GDPR violations, meaning they are violating you as they are taking your data and doing whatever it is without your consent or your knowledge. And so that's obviously an entirely different thing than simply feeling that you are quote unquote censored in some way, shape, or form. And for the most part, I don't consider downranking a form of censorship. It is basically slowing the spread of your message, but anybody can still go to your page, your wall, your account and read what you're putting there. So there is a distinction there to be made, but we'll see what happens. This is interesting. Probably going to get hate mail, but there you go. I'm curious to hear your thoughts on this. Just please be civil, or I might be able to sue you under Texas law. And please like, share, follow me here on Facebook and Twitter at NickAESP, where apparently if we live in Texas, we can sue them. And as always, or follow me on YouTube as well, please. And as always, stay safe, stay online, and please stay private. Thanks, everybody.